great points raised there about documentation. It seems to protect people involved going forward as well. So moving on to our next question. How are tribunal decisions reached, and what evidence tends to carry the most weight?
I think when I speak to employers around sort of, you know, what people will look at throughout the course of an employment tribunal, for me, there's always going to be three main areas. So documentation, firstly, i.e. what's in the contract, what's in the handbook. That's what they're going to be looking at in terms of policies and procedures, and, you know, I suppose how we get there. Audit trail, so everything that exists outside of the contract and handbook that remains relevant to the complaint. These will be the likes of your investigation notes, emails, WhatsApp communication, witness testimony as an example. That would serve as an example when it comes to, I suppose, the audit trail side of things. And the last area is the process. What process have we undertaken to bring about X, whether that be promotion, demotion, firing, whatever it might be. They're the three main areas that I would use as, I suppose, a risk radar. And the reason why I use those three is because it can take error in any one of those three areas for a claim to go on to succeed. Maybe not to the fullest extent. You know, if you've got 2 out of the 3 areas, you might be able to mitigate damages, but more often than not, it can be enough for a claim to succeed, even if it's not the full value of the claim, something can still stick. And again, you need to be wary that it's going to end up in the public domain. You know, if you've had a disability discrimination claim succeed against you in the health and social care sector, and if I do a quick Google search of, you know, yourself as a provider, and I see that you've got disability discrimination, how likely am I now to feel comfortable putting my mother with dementia or Alzheimer's in your care if you're discriminating against your staff? You know, there's far more ramifications outside of just, you know, I suppose the monetary loss. You also need to consider, you know, the damage and harm to your reputation and capacity to get future business as an employer as well. So then also recruiting. You know, if I do a Google search of, you know, I see your job ad, ABC Care Limited. See a job out there, everything looks all great, but then I type in ABC Care Limited and see that you've lost 2 tribunals, one for unfair dismissal and one for discriminating against your staff members. I'm probably going to look at you differently as an employer, and rightfully so. You know, I think anyone in that situation will probably have a couple of questions, but yeah, they're the 3 areas that I would look to look, and I suppose assess the validity and merit of any claim that, you know, I'm speaking to someone about. Documentation, audit trail, process.
And so it's part of your answer has answered some of the next question as well here, Kane, which is what happens if an employer loses a tribunal case. I think you've covered that nicely, but it also asks, and what types of awards can be made?
Yeah, so, you know, I'd say in my experience, probably 99% of claims are for money. You know, a lot of the time they want compensation. Some tribunals, and well, every tribunal has the jurisdiction to allow the employee to be reinstated, and for the employee to provide, you know, references for that employee as well. But the majority it's for money. You know, there can be different caps on awards. So the likes of breach of contract, that's a claim capped at £25,000. You know, certain breaches can be more significant than other breaches, as an example. So that's why you have that range. But there are also some that have no cap. So that will be the likes of discrimination. You can see claims that can go into the millions, into the hundreds of thousands, as an example. And there are different bento bands as well that can help the tribunal, I suppose, decide on the compensation as well. But again, certain awards can be made for the likes of loss of earnings, loss of future earnings, pension, injury to feelings, and such like. So these are all different things that can I suppose, top up the awards. There was quite a famous case within the health and social care sector. I think it was Nicole versus World Care UK Limited. And again, it's all in the public domain. You're welcome to go and look at this. But the summary of it is that there was an employee in a residential care setting. They developed quite serious health conditions throughout the course of their employment, and that condition amounted to a disability. They took sickness-related absence linked to that condition naturally, and the employee was subsequently dismissed after the employer went through a process. So, from memory, I believe that Ms. Nicole started to argue that the employer had failed to make reasonable adjustments. These adjustments weren't considered, and because of the disability, she was effectively terminated, and that her absence process was entirely mishandled. So the Employment Tribunal found that Ms. Nicole was absolutely correct. The employer did mishandle her sickness absence. They didn't make reasonable adjustments. They didn't consult occupational health or anything like that. And the dismissal process in itself was, flawed. It was substantively unfair. But the awards for that were extreme. They were £300,000. And that again included loss of earnings, it included future loss of earnings, pension loss, injury to feelings, but also interest as well. So again, these are things to consider. For me, it highlights that you need to really focus on how you manage things like sickness. The sector in of itself, again, the health and social care sector has one of the highest levels of sickness. So again, how you manage that as an employer is extremely important, because if you get it wrong, potentially you find yourself in a position like WorldCare UK Limited. So again, I would always suggest, if you're struggling with things like this, you want to make a change, just get some expert advice for sure.
Yeah, somebody commented in the questions box about this particular question, saying what impact can an employment tribunal have on the organisation's reputation, as well as staff morale and management practices as well?
It have a huge impact. I think that well, think about it. If you're a manager managing a process and that results in an employment tribunal claim, and that employment tribunal claim succeeds, as the manager, you're going to feel partially responsible. Maybe you are responsible, maybe you're not. So now you're feeling anxious. Maybe that spirals into you having to take time off work. It might lower your confidence as well. And now you're fence sitting when it comes to making decisions, whereas previously, you were on the ball, you were happy to make decisions, and you were happy with the outcomes of them. It can have a huge impact on staff morale, and also you start to see the cogs turning. Well, that happened to them. This also happened to me a few weeks ago. Well, is that discrimination? And you tend to find yourself in it can pollute the workforce for sure. A successful claim. Also, if it's a more intimate setting, a more family-run business, or people have got 6-7 years length of service, at the best of times. If someone comes in, it is almost like that family feeling, I suppose. And if someone takes advantage of that family, that family relationship and all the good that the employer's done for them, and then decides to raise a claim, that can have huge effects on the staff. They feel that they've been wronged in some way, that they've let this outsider in, and that they've taken advantage of the employer. So yeah, I've seen it have huge impact, both to the staff, both to the morale, to the workforce, but also to the reputation. More often than not, it can put some businesses under, and so some organisations choose to settle, so it doesn't end up in the public domain. But
and that's my next question. With all that said, is it ever better to settle a claim rather than to proceed to the full tribunal hearing?
I always try to avoid a broad brushstrokes approach. I'm an individual that I never tend to advise settling to any of my clients, regardless of the situation. Settlement can cause its own problems. It can create a culture. I've worked with a lot of different companies that have settled people out of the business when you're just thinking, well, you did have a fair reason to terminate. You didn't actually have to do that, and then one settlement turns into another, and then turns into another. Again, you would have seen in the news that NDAs within settlement agreements are now considered unlawful. So again, settlements can be equally as problematic. My advice to it for those that are in receipt of a claim, or potentially feeling like they may receive a claim, maybe something got a little bit messy, got a little bit personal, a little bit testy. Get advice so that you can understand the case and its merits, so you can understand what avenues are going to be viable for you. Some people I can understand. I was with a gentleman literally yesterday. I was with him for about three or so hours. He was telling me about the sleepless nights that he'd had because of the employment tribunal claim. The claim in of itself wasn't that large. It was only, I think it was 4 weeks notice. It was £1,740. But again, it kept him up night after night after night. And so I can understand why, you know, settlement can be appealing. You just sort of want it done and over with. But equally, there are going to be times whereby there isn't a requirement to settle here. You can put forward a strong and compelling defence. Again, it's also a common tactic for employees to potentially over-egg the cake. They inflate the claim, saying that we're looking for £70,000. They then present a settlement for £10,000, and it feels like you're getting a good deal. Again, I would just simply suggest getting advice on side well before the claim has even started. Make sure you've got some form of acumen, whether that be internal or external. But certainly at that stage, get an assessment, make sure that you understand the claim, its merits, but also how you might be able to defend the claim. You know, what looks very bleak from the outset can be quite swiftly resolved.
Fantastic, thank you. We're almost out of time, so I'm just going to go for one final question to kind of bring this together and give some practical help. So what practical steps can care providers take now to reduce the risk of tribunal claims in the future?
I think to rattle through this, have a specialist create your employment documentation, both your contract and your handbook, and ensure it's an accurate representation of how you run the business. Have access to competent and sound employment advice. Again, this can come in many different shapes and sizes. It can be, you know, you bring in a HR manager as an example. It can be you engage with someone like ourselves over at Tribunal, and we support the organisation from an employment law perspective. And again, you're looking at about £120 odd a month in the best cases. Have clear standards from the outset. As tough as it can be at times, avoid emotion and knee-jerk responses. Stick to proper methods of HR management for sure. Again, you know, often employees find themselves morally correct, but legally and procedurally wrong. So again, emotion can cloud judgment. So again, just take that time, just take a step back, you know, speak with your HR, speak with the organisation that's supporting you, and get some sound advice on it. Again, in a situation like this, where there's going to be so many changes over the coming weeks, over the coming months, over the coming years with the emergence of the Employment Rights Bill, again, have your documents reviewed by a professional. Again, pop me an email following this. You know, we review documents for free. We don't charge anything. We'll give you some advice on that, and try and get ahead of the curve. The Employment Rights Bill is not going to wait for anyone. The Fair Works Agency are not going to wait for anyone. They're looking at different types of pay, underpayment, when it comes to statutory pays and things like that. And the care sector as a whole is rife with issues when it comes to that. So I wouldn't be surprised if they're going to target the care sector first. So again, I think that's what I'd be looking for me. Get some help, get a professional to do it, get some internal or external acumen. But as of right now, you need to be acting quickly. You know, changes are going to be announced and rolled out as of April, the 2nd, the 3rd, the 4th of April. So get your documents reviewed, get ahead of the curve. And if you need some help with that, again, you're always welcome to pop me an email and we'll review them for you.
Fantastic. That's a great way to end. Just for our viewers here, can you just confirm what email address that they can use to get in touch with you, please?
Yeah, sure. So it's Kane. So that's Charlie Alpha Indigo November Echo .treasure, the same way that you would spell treasure chest, Treasure Island, at Krona, spelled Charlie Romeo Oscar November Echo Romeo.co.uk. You pop me an email, you can just put access skills as the subject line. You know, we're always happy to help, and yeah, I can get those reviewed for you.
Fantastic, thank you. Kane, once again, thank you for all of your expertise and knowledge. Really interesting session. I've learned lots from you today over the tribunals. And thank you to everybody who's joined us, for all of our listeners and viewers. Really glad that you made it to here again today. Hope you enjoyed the session and you feel more confident in understanding employment tribunals and how to reduce your risk in your own care services. If you do have any further questions, please do feel free to contact either ourselves at Access Skills or Kane directly. we look forward to seeing you all again at our next session. Look out for the marketing on that, on when it's going to be and what topic we're going to cover next time. Kane, thank you again. Thank you, everyone. Have a great day. Goodbye.